Hi, my name is Brian Morton, the Oklahoma driver's license attorney for the Hunsucker Legal Group and the Edge Law Firm. Welcome to the first of many Facebook videos that are going to be discussing the topics of driver's license here in Oklahoma. Today we're going to talk about some important changes that happened this year in Oklahoma implied consent law dealing with DUIs. Earlier this year, Senate Bill 712 was passed, authorizing the Department of Public Safety to enact rules to implement a program that changes the law. And it changes it very significantly. And there's been a lot of questions. So I'm here today to try to answer some of those questions through video. And as developments happen and changes happen and we get more information, we'll come back to you with more updated videos to get that information out to the public. So, big changes, implied consent law. Where do we begin? Well, the first thing is Senate Bill 712, it got rid of the Aaron Swayze Act. That's correct. No more 18-month, 4-year, and 5-year interlock requirements for your clients as a result of a revocation. That's gone. Now, DPS is still trying to fight that for individuals that were revoked prior to November 1st, and we're challenging that, but we'll give you more information on that on another video. The big thing to know is if you got a client that's revoked or arrested after November 1st, no more 18-month, 4-year, or 5-year interlock on the backside of that revocation. So your client's been arrested. What do we do? What are their options under the new law? Well, implied consent hearings are gone, at least with DPS anyway. Starting November 1st, anyone that was arrested November 1st or thereafter, you don't make a request to DPS for an administrative hearing. The days of getting a request in for within 15 days are gone. So what do we do? What are their options? Really, there's going to be 3 options available to your client. The first one is they're going to be given a notice of revocation that's going to revoke them within 30 days. They could just simply do nothing and decide to sit out the revocation. Now, the nice thing is the revocation periods are the same as they've been over the last several years. 180 days for a first-time revocation, 1 year for a second-time revocation within 10 years, and 3 years for a third or subsequent revocation within the preceding 10 years. So those time frames stay the same. So your client could just simply sit out the revocation. At the end of that revocation period, they can go in, reinstate, still have to do the drug and alcohol assessment and pay the reinstatement fees. So that's option number 1. Option number 2 is they could do the IDAP program. I'm certain many of you have heard about that and have lots of questions. What is the IDAP program? Well, first off, what does it stand for? It stands for Impaired Driver Accountability Program. In a nutshell, what it is it's very similar to the old getting a modification prior to having a hearing. But in this instance, there's not going to be a revocation if they enter and complete the IDAP program. Under IDAP, the individual applies for the IDAP program, and there's a form that DPS has. Unfortunately, they don't have it up on their website as of now. It was put out a couple of weeks ago on the OCDLA website, or the listserv, so it is out there and available for individuals. You're just not going to get it from DPS's website right now. So you apply for the form, it gets sent into DPS. DPS is then going to send you a letter that the person has been accepted into the program. Now they've got to enroll. Enrollment involves paying a $250 fee. $200 of that is for the enrollment fee, and $50 of that is for a restricted license. In addition, the time frame for applying, very important, 30 days. You've only got 30 days from the date they're given the notice of revocation to apply for IDAP. Once they get enrolled, they're going to have an ignition interlock device installed. And to get that interlock device installed, they've got 45 days from the time that they were given the notice of revocation. So it's a very short time frame that your clients have got to get everything done. So they get enrolled in the program. What does the program consist of? Well, just like revocation periods, the time periods for the IDAP program are the same. 180 days, 1 year, and 3 year, depending on prior revocations. So your client's in the IDAP program. How does that work? First thing is they're divided up between a phase 1 and a phase 2 in the program. In a phase 1, the individual is subject to being monitored by DPS, and they get interlock violations. If an interlock violation occurs, say we'll take a 180-day person. During the first 120 days, they're in phase 1. If they have a violation, DPS could take such action as sending them back for more training from the manufacturer who installed it on how to use the device, restricting them to the times and dates of use that they can drive, They could have them install an interlock that's got a camera, so it takes a picture of who's actually blowing into the instrument. And in the worst case scenario, could remove them from the program and end up having a revocation. The last 60 days of that 180-day is phase 2. During phase 2, the individual, if they have an interlock violation, would be subject to having their program extended for an additional 60 days. And they have to go the last 60 days of that program interlock ignition violation free. For a person on their second, for 1 year, it's the first 245 days for phase 1, and then the last 120 days for phase 2. And in that, if they have a violation, they have to have, it extends it another 120 days. On a 3-year, you've got the first year's phase 1, the last year's phase 2, and if they have any violations in that last year, it extends them for an additional year. So you've got the phase 1 and phase 2. To come off the program, they have to get a certificate from the Board of Tests saying that they've had no violations in the last time frame period. And then once they come off that, they get that completion certificate and they come off the program, then no revocation will appear on their driving record, and they won't have to pay any reinstatement fees. So now, what's an interlock violation? Well, according to DPS, an interlock violation could be 3 restart failures within a 15-minute time frame. You got an client that's going out trying to start their car and they're getting failures. Well, if they get 3 of those in a 15-minute time frame, DPS is going to consider that a violation. Another violation could be a rolling restart test failure. Now, DPS is going to allow them a little leeway at the beginning because there's going to be a learning curve. So the first 3 will count as a violation, as one violation, and then every one after that will be an additional violation. And then besides interlock violations, they also have program violations. Things like this would include trying to circumvent the interlock, missing an appointment to have the interlock data downloaded, or simply taking the device out without notifying DPS as to why the device is coming out. These likewise would result in violations under the IDAP program. Now, the third option. The third option is, remember I said that there's no hearing with DPS anymore. There is, however, still a direct appeal to the district court, and that's option 3. You have 30 days in which to file the appeal to the district court in the county in which the arrest occurred. You would file it just like you normally would, with the exception that under the new law, there's no longer a cash bond requirement. So you don't have to pay the cash bond in order to stay the revocation. What we recommend doing is in your order setting it for hearing, simply put a notice in there that the court is ordering DPS to stay the revocation. In addition, based on the guidance that DPS has put out, they've indicated that they're not going to make an issue of that. They realize that it was taken out of the law for the cash bond, but they're not going to try to make an issue out of staying the revocation while the district court appeal is pending. So you'd set the matter for hearing like you normally would, and you have your hearing with the district court. If you win, then the district court's going to set aside the revocation. So you win. But however, if you are not successful and the court finds that DPS has met its burden, then the new law says that the court shall grant a modification upon request. So the days are gone of the discretion with the court to grant a modification or not grant a modification, or to restrict your client's hours of driving. The new law says that the courts shall grant a modification, and a modification is simply the installation of the interlock device. However, there are some additional things that come with it that we didn't have prior to November 1st. One, DPS is going to be listed as the monitoring authority with the interlock provider. So the interlock provider is going to report any violations that we just covered over in the IDAP program to DPS. But here's where it's significantly different from the IDAP program. Under this, they have to do the last 180 days that they're that they're under revocation with no violations of the interlock. So for a first-time person on a 180-day revocation, if they have a violation 3 days in, well, they start the 180 days all over. If they have a violation of the 5th month, they start the 180 days all over again. However, it becomes a little bit more important when you've got a 1-year and especially a 3-year client. On a 1 year, they just have to go the last 180 days without any violations. And on a 3-year, they just have to go the last 180 days without a violation. So you can see the significance in that, where under IDAP, if they have violations in that last year, it adds a whole nother year to the program. Under a revocation, if they have a violation that lasts 180 days, it just starts the 180-day clock counting all over again. So those are the options that are available to your client. Almost forgot, on the revocation, just like it's always been, after the revocation period, they have to go reinstate, pay reinstatement fees, revocation on the record, and they have to do the drug and alcohol assessment. So that's going to be done whether you do IDAP or you have a revocation. But that's it in a nutshell. Sit out the revocation, do IDAP, or challenge it in district court. As we get more information, we'll be updating these videos and getting that information out to you. So until then, represent your clients.